think Sarah left the room, maybe. Did she?
You're all set. Go ahead.
All right. I will call the Zoning Board of Appeals meeting to order for Wednesday, December 10th, 2025. To all persons interested in or affected by the action of the Zoning Board of Appeals, you're hereby notified pursuant to Section 11 of Chapter 48 of the General Laws of the Commonwealth of Massachusetts and all amendments thereto that a public hearing on the following appeals will be held today, Wednesday, December 10th, 2025. The Zoning Board of Appeals public hearing will be held by remote participation methods. Public access to this meeting shall be provided in the following manner. The meeting will be televised live via Xfinity Channel 18 or High Definition Channel 1072. It may also be accessed via the Government Access Channel live stream on the Town of Barnstable's website, https://barnstable.comcast.tv/internet channel/watch-now. Real-time access to the Zoning Board of Appeals meeting is available by utilizing the Zoom link or telephone number and meeting ID provided. Public comment can be addressed to the Zoning Board of Appeals by utilizing this Zoom link or telephone number meeting and meeting ID. The Zoom link is https://townofbarnstable-us.zoom.us/j/849086 80792 or calling 888-475-4499 and entering the meeting ID 849-0868-0792. Applicants, the representatives, and individuals required or entitled to appear before the Zoning Board of Appeals may appear remotely and may participate through accessing the link or telephone number provided. Documentary exhibits and/or visual presentations should be submitted in advance of the meeting to anna.brigham@town.barnstable.ma.us so that they may be displayed for remote public access viewing. Copies of the applications are available for review by calling 508-862-4682 or emailing anna.brigham@town.barnstable.ma.us. So we will start the meeting with, we'll call the meeting to order with the introduction of board members. Herb Bodenseek.
Present.
Paul Pinard.
Present.
Aaron Webb.
Present.
Larry Hurwitz.
Present.
Manny Alves.
Present.
Natalie Pittenger.
Present.
Deborah Dworkis.
Present.
And I'm Jacob Dewey. So we have a full board here tonight. Notice recording this meeting of the Zoning Board of Appeals is being recorded and broadcast on the Town of Barnstable's Government Access Channel in accordance with MGL Chapter 30A, Section 20. I must inquire whether anyone is recording this meeting. If so, please make their presence known. Seeing none, we will move along. We don't have any minutes to approve tonight. So that puts us to our first item of old business, appeal number 2024-03925 Falmouth Road LLC has filed an appeal of administrative officials' decision in accordance with MGL Chapter 40A, Section 7, 8, and 15, and Section 240-88 of the Barnstable Zoning Ordinance. The appellant is appealing the decision of the building commissioner in issuing building permit BLDC 22-227 dated September 17, 2024. The permit was initially denied pending the receipt of a narrative to explain the expansion of the mechanical bays on the property. The appellant's position is that the permit fails to take into account evidence and documentation from the town records and files which conflict with the determination to issue the building permit. The subject property is located at 95 Falmouth Road, Hyannis, Mass, as shown on Assessor's Map 311 as parcel 073. It's located in the Highway Business HB and the Residence B RB zoning district. This is continued from November 13th, 2024, January 8th, 2025, February 12th, 2025, April 9th, 2025, and October 22nd, 2025. We did assign members, myself, Herb, Paul, Aaron, and Manny. Okay. I don't know if we're concurrently reading the other one into the record. Attorney Nickerson, do you want me to read the other one in?
Yes, please. Thank you.
Okay. And so concurrently appeal number 2024-040 25 Falmouth Road LLC has filed an appeal of an administrative official's decision in accordance with MGL Chapter 40A, Sections 7, 8, and 15, and Section 240-88 of the Barnstable zoning ordinance. The appellant is appealing the decision of the building commissioner in a letter dated September 4th, 2024. The appellant believes that the determination fails to take into account evidence and documentation from the town records and files which conflict with the determination and do not address the concerns raised as set forth in the appellant's enforcement letters and correspondence. The subject property is located at 95 Falmouth Road and 123 Falmouth Road, Hyannis, Mass, as shown on Assessor's Map 311, parcels 073 and 078. Lots are located in the Highway Business HB and the Residence B RB zoning district. This again continued from November 13th, 2024, January 8th, 2025, February 12th, 2025, April 9th, 2025, and October 22nd, 2025. And the same members assigned myself, Herb Odenseek, Paul Pinard, Aaron Webb, and Manny Alves. So I guess we're here tonight to discuss whether these appeals have standing. And Attorney Cogliano did give us a memo prior to the last meeting. So I guess I'll defer where you guys stand on what you have for where we are with standing on this.
Mr. Chairman, Mike Ford, I represent the applicant in the two appeals. At the last meeting, you charged me with, I took the position that I had a right to have a public hearing. That was questioned by Attorney Kenny and Attorney Nickerson and some board members, given the direction that the Attorney Cogliano had given you in a memo. I was charged by you of reaching out to the town attorney's office and discussing the matter and hopefully coming back with some agreed upon process for tonight. I did have a conversation with Attorney Cogliano, and I believe that she agrees that there is a right to have a public hearing and put the case in, but I don't want to speak for her. I understood she was going to be on and speak to the board directly about that. Okay,
so I'll defer to Attorney Cogliano, town attorney.
Sure. So Allison Cogliano, Assistant Town Attorney. I have not met a lot of the people on this call before, so it's nice to see you and meet you. Prior to the last hearing, I did send over and advise you on the law when it comes to an appellant establishing standing prior to you hearing an appeal. Chapter 40A requires standing before the board can actually not so much hear the appeal, but make a decision on the appeal. And so when I spoke with Attorney Ford, I also spoke with Attorney Kenny about this within the past few days. I do believe that Attorney Ford should be able to put forward his case. And the first issue that you all need to decide is whether or not he has standing to move forward so that the ZBA can then make a decision on the merits of the case, meaning you can decide whether or not to agree with the reasoning behind his appeal, or it will be dismissed because he has no standing based on his arguments today. So it's a little confusing, and I know there was confusion last meeting, so I'm glad I'm here to sort of walk you through the process. But at this time, I think we're all in agreement, and by we, I mean Attorney Kenny and Attorney Ford. I haven't had the opportunity to speak with Attorney Nickerson, but I assume that he's also on board. But I think what will happen is Attorney Ford will present his case. Attorney Kenny and Attorney Nickerson will be able to rebut whatever they need to. And then at that time, all you're deciding is whether or not the appellant, Attorney Ford and his client, have standing to appeal the issuance of the building permit. You're not deciding on whether or not you're going to accept the appeal and you're going to allow it based on the arguments. You're only deciding standing. And that's all based on the legal standard that I set forth a few months back in my memo. And I can remind you of that if you'd like. And I won't go too deep into it. But in order to establish standing under Chapter 40A, you must show credible evidence. Well, it requires a showing of credible evidence of a particularized injury to a legally protected interest. And if there's a whole lot of information and it's going to be too much, the board can make a vote on standing. The board can move to continue if you'd like some further advice from my office. It's really up to the board on how you want to move forward. And I think that will largely depend on how you take in Attorney Ford and Attorney Kenny's arguments tonight. So I'm here for questions, but hopefully after the arguments, things will be a little bit more clear, and then we can regroup afterwards.
Thank you, Attorney Cogliano. So in terms of going back to your memo and your legal opinion at the time was that there wasn't standing, correct?
Correct. So based on the letters that were in the opinions that went back and forth between Attorney Nickerson, I believe was the author of those letters, and Attorney Ford, based on the statements made by Attorney Ford in his letter, I did not believe him to have standing. And so that was my opinion in that memo. And that is why there was some confusion last time, because I was making a decision based on those letters. Attorney Ford had not had an opportunity to speak to you all directly during a public hearing and present whatever evidence he has to establish standing. And so that's what he's going to have the opportunity to do today.
Okay, so he has information and documents that he has not presented to you prior to that memo.
Basically at this point in time, we're looking for something above and beyond what was in the letter that he wrote, in order to establish standing, because I do not believe that he did so in his letter. Back in, I think, January, maybe there were a few letters, but I think Attorney Ford's was written in January.
Okay. Did you have a question for Attorney Cogliano? I think I saw your hand.
I was going to ask Deborah if she could just mute her microphone because there's an echo. It's hard to pay attention on a good day. Perfect. Thank you so much.
Mr. Chairman, may I make a comment?
Yeah, go ahead.
We, in the very beginning of this case, recommended a bifurcated approach. I think what Attorney Ford and his clients are entitled to is first a hearing on whether or not they have standing, whether or not this board has jurisdiction to hear their case. I don't think they're entitled to a full hearing on their claimed case, but merely on this question of jurisdiction or standing. If you find they have standing, then they're entitled to proceed with their full case. But I would suggest that the procedure, at least to start tonight, be limited to the issue of jurisdiction and standing.
Yeah, I think that was where Attorney Cogliano was suggesting we had.
I was a little confused. Thank you. I just wanted to clarify that.
Mr. Chairman, Mike Ford, can I make a comment at this point?
Yep.
So my understanding was that I was going to be able to put in my case, not simply narrowed to questions involving standing, but put the appeal in, and then Attorney Kenny, Attorney Nickerson, or whoever else wants to comment could put their rebuttal in. And once the board closed the public hearing, then the first issue was the issue of standing. And if the board decided, having heard the whole case, that there was no standing for my client, and they made that finding, they would never get to the merits, and the case would be done. It would be denied on the basis of a lack of standing. If, however, based on hearing the whole case, the board found standing in my client, then they would go on to the merits. It's, I mentioned to Attorney Cogliano, very difficult to hold a public hearing and decide, oh, well, that's outside the issue of standing, or that's beyond the issue of standing. That really you need to put your whole case in, because the board needs to hear all of the facts and then make a determination of whether the applicant has standing to be there. So That's, I think, different and distinct from what Attorney Kenny is saying, a more narrow hearing. I did have this discussion with Attorney Cogliano, and I believe that's where she came down. Excuse me, I'm suffering from a bit of a bug tonight.
Attorney Cogliano, I mean, the conversation that you and I had was, I think, more that we were tackling the standing issue, correct? Separately first?
Yeah. So we're only tackling the standing issue. However, based on my conversation with Attorney Ford, there's going to be overlap. There's an overlap, and I sort of explained this to Attorney Ford, where there are some facts that have to come in when he's discussing standing. I do believe that there's a lot of zoning issues and different things that, regardless of their existence, don't factor into whether or not Attorney Ford and his client have standing. And so I would just ask that Attorney Ford make the standing argument with as much of his argument that is necessary, or as little of his argument as necessary to adequately make that argument. And I understand, I do understand Attorney Ford's position that a lot of the facts that would be included in his argument are going to be relevant to the standing issue. I just don't believe that 100% of the appeal will be. So I would just ask that Attorney Ford try to limit it to what he believes is necessary to establish standing.
Okay. So we should open the public hearing on the items, correct? And proceed as it was noticed, but ultimately we are making a determination on standing.
Correct.
Okay. All right. So do any other board members have questions?
I have a question.
Go ahead, Larry.
The town attorney has already found that the appellant does not have standing. Is that correct?
Her opinion was that based on the information she had at the time that there was not standing, but Attorney Ford is going to present further information to us to help determine, or again, I think we could be in a position where we send it back to Attorney Cogliano to give us a revised opinion of that as well, I think is another alternative way we end up going.
All right, I understand now.
All right, so we have members assigned.
Mr. Chairman, I have a quick question.
Yep.
Can we pose the question to Attorney Kenny and Attorney Nickerson whether or not Attorney Ford's approach is valid or with them or not? At this point, to me, it seems like, again, I understand we've been over this before with trying to determine standing and Attorney Ford struggling with trying to make his case with or without information that may or not be, pertaining to it. So is there a angst or that they don't want that to be the case? I'm just curious. Meaning, can we just hear the whole thing and then decide, as Attorney Ford said, whether it has standing, and if it does or does not, we then, based upon, and then we go to the merits of it?
Well, if that's how the board wants to proceed, that's fine. We, as I said in the very beginning of this case, suggested a bifurcated approach. If Attorney Ford's going to put in his entire case, I guess we would respond to the jurisdictional question, the standing question, ask you to make a determination. Once you make that determination, then we can put our case in rebuttal. Our full case in rebuttal to his full case.
Yeah, this is Paul. I think we ought to follow town councilor's suggestion that the initial argument here is not the full case hearing, it's a question of standing. And I think we ought to proceed in that manner.
I agree with you, Paul.
I would agree. I mean, I think from the outset, this was bifurcated pending receipt of town council opinion on the standing question. That's where we are.
That's fine, no problem. I'm good. I just
We got an opinion.
Yeah.
And that, and frankly, I think Attorney Ford, I'd ask that you start with that memo and basically tell us what is it that the town council didn't take into consideration that would be contrary to her opinion that you don't have standing.
Okay, so we have members assigned. So I'll open the public hearing on the matter, and I will turn it over to Attorney Ford.
Yeah, and thank you, Mr. Chairman. And trying to respond to Mr. Alves' suggestion. Mr. Alves, I asked for a hearing and discussed it with Attorney Cogliano, recognizing her opinion, because she concluded that we had not presented any evidence that she felt in her conclusion that showed that there was standing in my client. The problem I had with it, with my town council hat on, frankly, is that there hasn't been any evidence in this case. She issued the opinion before members were assigned. The hearing had not been opened, and nothing had actually been submitted in terms of evidence. Now, yes, there was letters back and forth, and I was given an opportunity, thank you, to the board to be able to submit my letter as well. And based on those letters, she came to a conclusion. But I think when I spoke with her, I think she realized that you can't make a finding of no standing and deny an appeal when 40A says that you have a right to a public hearing. And until the appeal is held and a hearing is held, you can't make a conclusion that there isn't any standing, because standing in and of itself is a factual question. And thus, it was my position that that needed a public hearing. If the board is looking for me to stay within the four corners of the initial letters, I will try to do that. I don't think that's the state of the law, but I'll certainly try to do that, because I'm not going to make a presentation that the board has made a decision they don't want to hear, or that Attorney Cogliano is suggesting that it be that narrow. But
pardon me for interrupting, but you may have misunderstood me. I did not mean to limit what you can present. What I meant to say is, I take the memo from Attorney Cogliano as laying out the law. Our role now is applying facts to those laws. So in your role, as I see it, not to tell you what to do, is to present your client's side of the facts to see how they fall within the contours of the legal parameters laid out in that memo. That's what I meant. I didn't mean for you to.
I understand. And maybe we're on the same page. We're just talking about it a little differently. So if I may, Mr. Chairman, then I'd be happy to maybe to make things more expeditious. If you want to read them both in, we could do them at the same time, because I think the facts with respect to standing are going to be similar in each case, and I'd be happy to proceed in that fashion if that would be helpful to the board.
I did read both in to the.
You did, okay, all right.
So I mean, the public hearing's open on both.
All right, okay. So, for the record, Michael Ford, and I represent the appellant in these cases. The appellant is 25 Falmouth Road, LLC. It's a limited liability company. And as indicated in the papers that have already been filed on the issue of standing, that's the site of the Audi location. It is not within the 300-foot area called for in the statute to receive notice as a person in interest or a party in interest. And therefore, I would concur for the record that they are not assumed to have standing. That said, the issue that my clients have raised with respect to the four properties in question, or really the two properties in question, 95 Falmouth Road and 123 Falmouth Road, goes to the issue of the use of those properties. And as Attorney Kenny pointed out in his memo, they're being put currently to a use similar to the use that my client conducts on his property, an automobile dealership and service. In our appeals, we have raised the factual issue of whether or not the service on these two sites, 95 Falmouth Road and 123 Falmouth Road, are legal. And that question turns on a finding as to whether they are pre-existing non-conforming on the issue of service. Why? Because there never has been, to my knowledge, or I could find, a permit issued to either site, either 95 Falmouth or 123 Falmouth, that granted service per se. In other words, the right to conduct automobile service on those sites and to have X number of bays and lifts. And it is the lifts that is the key here, at least in my view, to whether or not my client may have standing to pursue this. Why? Because the lifts are the aspect, or the major aspect of service, I'd suggest, that invokes the prohibitions of the Groundwater Protection District that all these lots are in, both my client's lot and 123 and 95. They're all in the Groundwater Protection District. And so automobile service is a prohibited use. When my client redeveloped the Audi dealership, there was a very lengthy review of that question of what was pre-existing non-conforming in terms of automobile dealership and service. And once it was determined through physical inspection by the building department, even prior to our site plan review, and pictures and so forth of what the various bays were and the lifts were, a memo was developed as to how much hazardous materials a particular bay or lift utilized. That's important because we're bays or where hazardous materials have been allowed at all on 123, there's always been a condition that they can't have more than 25 gallons in that entire building. So the enforcement action turns on the question of whether these are legal bays. It appeared to me in doing the research that 95 Falmouth, where Prime Motors was at one point, did indeed have a claim for pre-existing non-conforming. That is, factual existence of bays and lifts and automobile service prior to the prohibition in the Groundwater Protection District of automobile service. I could find no such evidence for 123. And in the case of 95, the only evidence that I could find was there was somewhere between 4 and 6 bays at one time. So the question that was raised in the enforcement request is, when Prime, that used to operate a Mercedes-Benz dealership there, left, and all of this is in the papers that are in your files, and so I'm not going to go into great detail. I'm going to try and stick with what I believe is the standing argument. That there did appear that there was a 3-year lapse in the use of the bays that existed in 95. That's a factual issue. There was a long letter from Attorney Kenny to the building commissioner setting forth the reasons why he felt that they had not been abandoned. It was a complicated letter. I challenge you to read it. In some parts, it argues that the mere fact that a license is issued is evidence that the use occurred. And in our letters to the building commissioner, we pointed out that there are cases that would suggest that the mere issuance of a license it does not constitute a use. And so you need to look at that one closely. It turns at the end of the day on some affidavits, at least for the building commissioner, that Attorney Kenny attached to his letter. They were affidavits that that building and 123 Falmouth Road were both leased by his clients to do prep work on new automobiles that were part of the Class 1 dealership down the road at Ridgefield for the Chevy Subaru place where it was located at that time. And so my concern was that that was not unauthorized use. There was no license that indicated that automobiles for that Class 1 dealership were to be, if indeed it happened, to cut off the 3-year abandonment provision. So that's the factual issue. I'm not going to go into it further than that. I'd like to if I get to the merits, but I just wanted to kind of paint what the picture was. With respect to 123, I couldn't find any evidence of pre-existing lifts or service. Indeed, I found just the opposite. I found a series of letters in the building department file from various employees there working in the building department upon inspections, finding that there was not pre-existing nonconformities there and not allowing certain uses that attempted to go there to perform that type of service. Again, Attorney Kenny's letter to the building commissioner addresses that through a series of licenses and the words on the licenses. But if you read the letter closely, he says that the two buildings have 10 bays, and the paragraph would seem to suggest that the 10 bays are laid out on the licenses. Well, they're not. And indeed, if you look at those licenses, I couldn't find one that said there were 10 bays. The building inspector himself, in February of, right after we filed our second request, denied the building permits. And he sent an email. And again, I'll try to keep this just to the issue that I'm going to try to suggest gives us standing. After we filed our second request, this went on for a couple of years before he made a decision, as you're probably aware if you've looked at the record. This comes from Brian Florence as part of your record. Attorney Ford, thank you for your email. Permit number BLDC 22-227, that's the one that we've appealed, was denied for the following reasons. Denied pending further submittals. Provide a zoning narrative to explain the expansion of mechanical bays. Well, if you go and look at Attorney Kenny's letter that was submitted after that denial, there is nothing in there that talks about how there was an expansion of mechanical bays. There's a visit to site plan review. There's a Board of Appeals decision and a use variance to allow the back part of a couple of lots on Walton to be used for parking, accessory to the dealership. There is some site plans that are involved, but there's nothing from the Board of Appeals who would need to authorize a use that's prohibited in that zone. And the history of 123 was that it was always limited for the entire building to 25 gallons of hazardous waste. And that's written on the licenses. Now, how much hazardous waste does a one lift use? In my experience in representing automobile dealerships, it's in excess of 100 gallons. So you couldn't have a lift if you've got a condition on a building of 25 gallons. So that's kind of the factual issue about the merits. I'll go into it in a lot more detail if I'm afforded that opportunity, and that's obviously your discretion as to finding whether or not we have standing. So how does that give us standing to be here to bring these important matters to your attention in a groundwater protection district? The Audi property is in the groundwater protection district. There are cases, one of which I cited in my memo, which indicates that properties are to be treated uniformly in a zoning district. And if a property located in a zoning district is affected by the fact that other properties in that district are not being treated uniformly as to uses, that's a property right. And I stated that in a very general sort of a way in my letter, but that frankly is one of the reasons that we've brought this. The other reason we brought this is, I'll admit, a novelty, if you will, with respect to standing. And that is the question of uniform application of regulations in the town. And my client is of the opinion, having redeveloped a number of sites for automobile dealership, that rightfully so, most all of them are in the groundwater protection district. That just happens to be the way Hyannis is laid out from a zoning and water standpoint. That there has been a very rigorous review, and state-of-the-art lifts have been required to be installed, which use oils and other lubricants and solvents that are not as adverse to groundwater as the normal ones. My client asked me whether I saw any of that review in either of these two buildings. And I said, no, I couldn't find any evidence of it at site plan. Questions weren't even asked. No letters were provided, as they were in his redevelopments, setting out how many pre-existing lifts there were, what would the new lifts be, how much hazardous material would there be, and is there a net gain or is there a deduction? And frankly, the Board of Appeals in those cases, or the building commissioner, because many of them didn't get to the Board of Appeals, required that analysis and encouraged a decrease, as did the Water Department, as did the Board of Health, that there be a net decrease in hazardous waste if the redevelopment was to occur. So my client said to me, well, geez, if that's the standard that's being applied several hundred feet down the road, why isn't that the standard that's being applied everywhere? And I would agree with the town attorney's office, Mr. Chair and members of the board, that do I have a case that says that? No, I don't. But the law of standing was not meant, and I cited the case in my memo, to be a hard and fast rule. It's one to be flexible and to take into consideration the facts that are before a regulatory board at the time. And so I put that information before you and suggest that in this important case, that is something that this board should find standing and should hear this matter, frankly, and get to the bottom of it. And see whether, in fact, there is something here or there isn't. Because what is at issue is not only my client's rights, but frankly, the rights of everybody who lives in the town with respect to keeping the groundwater protection districts safe. And when somebody's claiming a non-conforming use, that it's proved and that it's held to the highest standard, to the way it's been done for others. So in a nutshell, my argument in terms of standing is the case that I cited that said standing is not a hard and fast rule. and is to be flexible and applied to the facts of each individual case. I found a case that says standing is imbued when somebody's held to a different standard. No, I haven't found a case. Does that preclude the Board of Appeals from going in that direction? I'd suggest absolutely not, that there is discretion with the board, that just because those facts haven't been necessarily decided, you have a right, as you conduct your proceedings and decide which cases come forward and don't, to take a look at that. And I would encourage you to do it in this particular case. And so, Mr. Chairman, I think rather than getting to the merits, which is where I've got this stack of papers next to me, in fairness to what I think the board has asked me to do, I'll end there on the issue of standing, reserving my right, if you decide standing on the facts I've given you, and you allow me to go further, then I will present the rest of the case.
Thank you, Attorney Ford. Board members, so I guess Attorney Ford, so you're stating that your client is a person aggrieved due to it affecting their groundwater? Is that where you're going with that?
No, I'm suggesting two things. First, there is a case that says that people get standing if to complain about uses being conducted in the same zoning district that are not permitted. And so my client runs an automobile dealership. And so, as Attorney Kenny said, well, he's running the same use. And to which I respond, yes. At a level 1, where the nonconformity was adequately proved, and 2, where the redevelopment of the site and the use of the lifts was reviewed by the town and required to be upgraded to state-of-the-art to protect the groundwater, not his groundwater, but our aquifer lens. So that's the right of anybody who lives in any district to make sure that the uses being conducted are uses that are indeed permitted. That's the first thing. Second part of that argument, closely related, is the one that Attorney Cagliano in her memo said she didn't believe it amounted to standing. And I'm the first one to admit I haven't got a case right on point, is that this failure to uniformly apply the regulations on uses within the same district is something that is a property right of my client. He should expect that. And that is being violated here because not all properties are being treated equal on an issue that is of utmost importance, and one which one property owner has been required to address at great expense, and another property owner is not being asked to address. So those are the two issues closely related.
Okay. Board members, thoughts, questions, Manny?
Yeah, I have a couple. So let's unpack those one at a time. If I understood you correct, and I may not have, your point is that the uniform application of the regulations is something that is a property right, you called it, that gives your client that may constitute particularized injury to give you standing. I'm trying to put it into the language of the existing cases.
Yeah.
Is that right?
That's correct.
And you're saying that the actions of the zoning officer, in this case, in disparately applying those regs, harmed your client enough to give you standing. I'm trying to understand to see if I understood what you said.
Yeah, and I don't think it's a question of whether he's harmed enough, whether it gives him standing to bring the question before the board.
No, but you have to have harm to have standing.
That's correct. And the harm is the desperate treatment. You're correct.
Okay.
So, but you said harm enough. I don't know, frankly, what is enough. I mean, I'm
Point
you know,
taken. Point taken.
Yes.
Some harm, some level of harm, enough.
Yes.
Okay. I guess my question is this, thank you for thinking we have the authority to maybe even break new ground of law here, because as you say, that doesn't seem to be the prevailing view of the law. So is this, and maybe this is a necessary step before you take it to a court to ultimately make the decision on the law. But I'm wondering if you're asking us to expand the law of standing, and I'm not sure that's something this body has an authority to do. That's my question.
I hear you, and that's a good question. And frankly, you should, and you probably will, consult with the town attorney with respect to that, as opposed to me as the applicant's counsel. But I do feel that there is discretion with the board. It's not often that a board of appeals is asked to wrestle with the question of standing. I remember being involved in some standing cases years ago before the Barnstable board, and the consistent line of advice from the then town attorney, who was town attorney for many, many years, Bob Smith, was that he advised the board not to get into the issue of standing, to hear cases on the merits, and if there was a standing issue, it would get sorted out in court at the next level. And it wasn't for a board to get all tied up in knots on trying to figure out the cases and whether there was particularized harm or there wasn't, but to hear a case on the merits and decide it one way or the other and let the issue of standing play out up above. I guess I kind of cut from that same cloth that this board has discretion if they feel something is properly before them to hear it and leave the niceties of standing to a judicial forum at another level, if in fact it goes to another level.
So let me ask it differently, because as I understand the concept of standing, for a party to appear before a quasi-judicial board, it needs to show that whatever action is taken, is being proposed to be taken, would result in harm to its right. That's conceptually that's the law of standing. And is it fair to say that we only get there if this board agrees with you that your argument that uniform treatment, uniform application of the regs is a property right?
Well, I'm arguing two things. I'm going to answer your question, but I want to make sure that I am arguing two things. The other is that uses that are not supposed to be allowed in the district, everyone in that district has a right to bring to the attention of the Board of Appeals a use that's supposed to be permitted in that district for the protection of the district as a whole. That's a question that can come before the Board of Appeals. There is case law on that. Now, putting that aside and trying to answer your question directly, if you don't decide that my client has standing, I would suggest that my client is just as much harmed as because he walks away with knowing that in his mind that the desperate treatment was allowed to proceed. I, of course, will advise him as his counsel that that's not what the Board of Appeals is saying. What the Board of Appeals is saying is you didn't have standing, so they didn't have jurisdiction, so they didn't get to the issue. It's not that they decided it. So I and I will do my best to talk to him about that. But I'm sure there'll be a feeling on his part that there is harm, and the harm will go on if your board decides not to hear the case.
Thank you.
This is Paul. Part of what I'm hearing is if I am a citizen in a particular zoning district and feel that I am harmed by an event in that district, regardless of how many feet away I am, then I have the right to appeal or bring it to somebody's attention. The question I have is this the venue that occurs?
Well, it has to occur at the building commissioner's level first, Mr. Pinard. You've got to exhaust your administrative remedies before you can get to this board. And so it would always need to go to the building commissioner first. And in these types of cases, these enforcement type cases or appeal of building permit cases, the reported cases, there's a green case that Mr. Nickerson correctly cited out of Provincetown years ago, where the court actually said that somebody may have the legal right to request an enforcement action to the building commissioner, but unless they're aggrieved, they can't go to the next step, which is take it to the Board of Appeals, which seems to me to leave that person without a remedy. And is probably crying out for somebody to challenge that and take it forward, because appellate courts don't look upon a situation where somebody has no legal remedy fondly. Has been my experience in the law outside of zoning.
So, board members, I mean, we've got a couple options here, and Attorney Cogliano, do you want to weigh in here on how we want to proceed, or do we want to hear from Attorney Kenny and Attorney Nickerson?
I was going to say, I think if the board wants to give Attorney Kenny and Attorney Nickerson the opportunity to rebut, I think that'd be appropriate at this time, just so that the board has a full picture. And then at that time, if you have further questions, you can ask, and then we can move on to deciding on whether or not to, or what motion to take.
Okay. So Attorney Nickerson, Attorney Kenny, did you guys want to respond to that?
Yes, Mr. Chairman, we'd like the opportunity. For the record, Attorney John Kenny, our office in Centerville, representing Gilbert Wood and Troy Wood, trustees of 123 Falmouth Road Realty Trust. We also represent Copeland Subaru of Hyannis, the tenant in the building. And I'm going to remember this, Attorney Ford, if I ever have a case in front of the town that you're the town attorney for, because apparently standing doesn't matter. Under Attorney Ford's theory of standing, anybody in town would be entitled to a right to a remedy by coming before this board. The fact of the matter is that this was a zoning dispute. They brought enforcement actions, which they were entitled to do. They received a negative determination. The building commissioner, after a thorough investigation, upheld our position that our client's use is illegal, pre-existing, non-conforming uses. They then filed these two appeals with the Zoning Board of Appeals, and we challenged them because they're over 550 feet away, 4 properties in the street. We're in agreement that they are not a party of interest, as Attorney Ford indicated, and we're in agreement that they have to show that they're an aggrieved party. That is not some abstract standard. That's both in Mass General Laws, Chapter 40A, and in our zoning ordinance under Section 240-88. To appeal a determination of the building commissioner, you have to be an aggrieved party. You heard nothing about aggrievement. What you heard was Attorney Ford's client upset that he thinks there was disparate treatment when he tore down an existing facility and built a new facility and had to build it to new current codes. Ours is a legal pre-existing non-conforming use. It continues. If and when our client decides to tear down their facility and build a new facility, they'll receive the same treatment. They're at different stages in development. So to argue that they're entitled to the uniform application of the zoning ordinance, isn't everybody? And they had that opportunity. They went to the building commissioner. He made a determination, and the building commissioner said no, and now they can't show aggrieved party status. And in fact, There is a Supreme Judicial Court case that reaffirmed the principle that an alleged zoning violation is insufficient to confer standing without individualized requirements that establish standing. That's Murchison versus the Zoning Board of Appeals of Sherburne. It's right on point to the argument that the disparate treatment of under the zoning ordinance confers standing. The SJC has clearly stated it's insufficient without the requirement that you establish standing by showing a personalized harm. There's no allegation of personalized harm. The other argument about protecting the groundwater. Does anybody that's in the same water district, or because we have a single source aquifer, does anybody in town now have standing to challenge anything that they don't like, a particular use? And there's a case on that. In Sweeney versus AL Prime Energy Consultants, the Supreme Judicial Court again found that a concern of groundwater contamination without more is insufficient to confer standing. Individualized injury must be established. You heard nothing about injury other than some hurt feelings by a developer who developed a couple of properties, who wants somebody who hasn't developed properties to be held to the same standard that he was when he developed new properties. It's nonsensical. There's nothing alleged for individualized harm. There's no harm other than holding up a competitor and putting him through the ringer for really no other reason other than the fact that he apparently doesn't want the competition. So I would suggest to you, everything that Attorney Ford said is against Massachusetts law, the SJC findings. They're both right on point. They're in our papers that we submitted. He couldn't identify any individualized harm. There's no allegation of groundwater contamination from our property affecting theirs. There's not even any allegation of groundwater contamination from our property affecting the groundwater. And again, the disparate treatment under the zoning ordinance, this is a zoning dispute. That's not sufficient to confer standing. And again, there's no harm other than supposed bad feelings by the developer. The building commissioner has looked at the record. He's made a determination. I would ask that you find that the appellant lacks standing, or in the alternative, we would present additional evidence supporting the building commissioner's determinations. I'd be happy to answer any questions the board may have.
Thank you, Attorney Kenny. Board members, do you have any questions?
Yeah, I do.
Go ahead, Natalie.
Okay, yeah, I just want to be sure I understand exactly what's going on here. It sounds like, so we have two dealerships. One was just an existing dealership. Another one was a tear down and rebuild. And somehow they both had different qualifications vis-a-vis the town. Is that right? In other words, different things happened. Okay, all right. So, and yet I kind of agree with Attorney Kenny that, so as a result of those different qualifications or standards, I mean, nobody has really suffered anything yet. Is that right?
I certainly agree.
It depends who you ask now.
All right, I'm sorry, Aaron, I didn't hear what you said.
I said it depends who's going to respond. I mean, certainly Attorney Kennedy sees nobody being harmed, and Attorney Ford would argue against that. So anyway, go ahead. I don't mean.
Yeah, no, I mean, I would give Attorney Ford a chance to enlighten me why I should think otherwise. But it just seems like you have two similar business situations, and one had to install yesterday's light bulbs and the other one didn't. Something like that. And I'm trying to get a handle on what specifically was so outrageous about the second dealership requirements.
And if I may, Mr. Chairman?
Yeah, Natalie,
I'll try and keep it just
standing here, not necessarily on the actual merits of the case. But yeah, go ahead.
I'll try to keep it as narrow as I can. So, Attorney Kenny's clients were challenged by my client as to whether or not the service that they're conducting in those buildings is legal. Yes, that's the stage they're at. That's a different stage than redeveloping, but that's the first stage. And you're required at that stage, in my experience in Barnstable, to be able to come forward with evidence to prove. And that involves a lot of things, and I haven't gone into all of those things, but I mean, there's like reporting with the Board of Health on the amount of hazardous waste, and I'll get into all that stuff if we go into the merits, that I'd suggest to you at least opens the door to what is really going on there. And does the town know, and is it being run in a safe manner? And is it entitled to pre-existing non-conforming standard? And that's the question, and that's the difference. And what is really happening there, I don't think we really know yet.
Well, if it was pre-existing nonconformity, then they were allowed to do certain things, correct?
Right, right. Okay. And in order to be pre-existing nonconforming, you've got to be a use in existence at the time that the bylaw that makes you non-conforming. You can't pop up afterwards under some form and then morph into all of a sudden a service base. Doesn't happen. If it does happen, then it's not legal. So I mean, that's what I'm talking about here.
I think we get into a chicken and egg issue here. You don't get to contest the zoning officer's findings before this board unless you have standing to bring this matter. I think that's Attorney Kenny's position. It's a prerequisite. And I guess I'd like you to address his point about particularized harm. How is it that your client is, again, using the words of the SJC, in an individual way harmed by the action approved by the zoning officer? And so I come back to the desperate treatment. And do I have a case on that? I told you right out of the box that I do not. But I did remind you of the case where the courts have found in Standerwick that it's not a hard and fast rule. Standing is an evolving thing and needs to be applied as you look at each situation. And so my view is that there will be standing will expand, although there have been some legislative enactments of late that have narrowed it. So those who make the laws, I'll be the first one to admit that, because there has been some of that in an effort to cut out perhaps some court dockets and reduce them a little bit of some of the cases that they've been dealing with. And I understand that. But I'd suggest that this factual situation is unique and one that I would ask you to take a look at under that light. Yeah, and I appreciate. I'm going on and off here. I thank you for that. I appreciate your candor, because I guess the difficulty I'm having is whether this is the board that has the authority to delve into new areas of the law. I mean, if there is no established law on this point, I'm not sure that we're the ones to make it. So thank you I appreciate your candor, though.
May I respond to Mr. Ells?
Yeah, go ahead, Attorney Kenny.
There is established law, Mr. Ells, and it's the case I cited, Murchison versus the Zoning Board of Appeals of Sheridan. Again, this is a zoning dispute, and the case stands, as stated, reaffirms the principle that an alleged zoning violation is insufficient to confer standing. And that's all we're talking about here is alleged zoning violations. Insufficient to confer standing without individualized requirements that establish standing. And they haven't pleaded any.
I would just add that case, Murchison, involved a lot with issue in a undeveloped over 1 acre lot in the town of Dover. The plaintiff in that case, Murchison, lived either immediately next door or across the street, so was within the zone of presumed standing. Despite his presumed standing, the SJC found there was no actual standing based on the reasons Attorney Kenny provided.
No, and I get that, and trust
Well,
me.
just a point of order, Attorney Dickerson, can you just identify yourself as in Attorney Kenny's office, just for the record?
Yes, of course. My apologies. Patrick Nickerson, Associate Attorney at the Office of John Kenny, also representing the property owners. Thank you.
Go ahead, Manny. And then
I know those cases. I understand the need in a zoning action that there has to be individualized harm to the party seeking to contest the action. I get that. I guess what Attorney Ford is asking us to consider is whether is the individualized harm, can it be the sort of, for lack of a better phrase, arbitrary and capricious application of the in other words, if I live more than 500 feet away and and I was subjected to a certain rigor in developing X, whatever that happens to be, someone down the way is put through no hoops at all, is given a carte blanche to go through. Have I been harmed? And it's that he's asking us, if I understand him correct, I don't mean to speak for you, Attorney Ford, I just don't think we're the one to make this determination, whether that kind of disparate application of what should be equally applied to everybody gives them standing to contest. I don't think it's before this board. I think you may have a case before court of law, but because I agree with Attorney Kenny that the cases in the books on standing require you to show particularized, individualized harm. Anyway, interesting. I'm not sure I get there.
Aaron.
Yeah.
Mr. Chairman?
Yeah, go ahead, Larry.
I think since we've heard from both attorneys, I'd like to know what the town attorney, feels after hearing both of the attorneys.
Yeah, let me just go to Aaron first, and then I was going to go back to Attorney Cogliano. But Aaron, I think you had your hand up.
I did, yeah. I'm searching through both town of Barnstable zoning rules and regulations, as well as Mass General Laws, chapter 40. Can't see a definition, a clear definition is distance related to somebody being aggrieved? Is it 500 feet? I mean, is that a clear barometer of property, owner saying I'm aggrieved and go ahead, Attorney Ford.
It's 300 feet, and it's in Chapter 40A. And
okay, I couldn't find it.
What it says is that anyone who's required to notice, which are abutters to abutters within 300 feet, and those directly across the street. Those are the people that are parties in interest who get notice by statute. That group is viewed as presumed to have standing. And so they have a right to bring this appeal. And then if standing is questioned, they have to prove standing. But they have a presumption that they have it in the first instance. And that's a 300.
And does your client fall within those parameters?
He's outside the 300 feet. He doesn't get the presumption.
So I don't get it. But I also don't understand where we keep hearing this word aggrieved. I'm looking up the definition of aggrieved, and it's basically somebody who's feels they've been treated unfairly. So again, and I believe your client is aggrieved. I mean, in that regard. But again, if he's not within the parameters of being able to file an appeal of aggrievement because his properties aren't close enough to the actual property. I don't know what we're doing here.
Well, you can still be aggrieved, if I may, Mr. Chairman. You can still be aggrieved.
I agree. I'm aggrieved all the time. But but again, if it doesn't fall, if he's outside the parameters of the 300 feet, that seems to be a clearly defining parameter of, in this case, appealing on aggrievement. And so
that's only gives you a presumption. You can be aggrieved and be outside the 300 feet. For example,
I agree. I'm aggrieved.
I'm representing the canal plant. We file for a new 200-foot stack. People can see it 1,500 feet away. They're just as much aggrieved as perhaps somebody who's.
I agree, but
agreement all depends on the factual situation. That 300 feet is just a presumption for those that live within the 300 feet. They get a presumption.
okay. Attorney Kenny, can you respond
Attorney
to that?
Kenny, and then we're going to go to Attorney Cagliano just to give us
Yes,
some.
the case law defines a person aggrieved as somebody who has a plausible claim of a definitive violation of a private right, a private property interest, or a private legal interest. The fact that they have bad feelings because they felt like they get disparate treatment by the building commissioner doesn't fall within that category. They are not an aggrieved party.
Okay, so Attorney Cagliano, can you give us sort of like a summary or an, I don't know, opinion of where you'd like this to go? I know you sort of put together 3 options here, maybe to summarize those for the board as well.
Sure. So I did provide some sample language on 3 different motions, one that finds standing, one that does not find standing, and one if you all members of the board believe that you need either me to weigh in further to continue it. I will say before you decide on which motion you'd like to move forward with, I haven't heard anything this evening that is above and beyond what was included in my memo. So I stand by my opinion that was set forth in the memo. You all should make your decision based on what the arguments you've heard tonight. But I'm not sure that continuing it, I don't think that I would really have much to add if you'd continue it. So, but again, it's up to you all what you'd like to do.
Okay. And then Attorney Cagliano, so like it's an open hearing right now. I mean, do we take public comment on the issue of standing, I guess, or?
That's a very good question. I don't think so. I think that that's a procedural issue. I think that the issue on the merits is something that would be subject to public comment.
Okay.
That's my opinion. I don't know that public comment is necessary on the standing issue.
Okay. Board members, does anyone have a direction they'd like to go? I mean, the biggest determination here is if we have a person aggrieved under Chapter 40A. I mean, I think it's what we're being asked.
Mr. Chair, I think I agree with town council. I don't know that public comment bears on this. I think we should close the public hearing and vote on what we've heard and whether the law is laid out by town council and it doesn't seem to be a disagreement on the law, whether there have been facts presented that would I mean, actually, we've heard it. I mean, the opinion of town council is there's been nothing presented that would cause her to change her opinion. And I haven't heard anything that would lead me to stray from that advice. So I think we should vote on it.
So are you making a motion to close the public hearing?
So moved.
All right.
Mr. Chairman, if I may.
Yep.
We have to determine the issue of standing, but if you find that there is standing, there would have to be more public comment because both Attorney Ford and I would have additional information to put in. So I think you need to keep it open, make your vote on standing and then close if you vote the way I want you to vote.
Okay. Yeah, Attorney Cagliano, does that seem procedurally correct? So
I agree with Attorney Kenny. And if you feel as though, I mean, you can ask whoever is in this meeting if there is anyone here for public comment. I think that the attorneys, myself, we've all made our arguments and shared our thoughts. But I guess in the spirit of completeness, you could also, but I think also after you make the decision on standing, if you voted that there was standing, there would be a separate, there would be an opportunity for public comment on the merits. So
we'd read open the hearing. So I guess I'll bring it back to the board. Is anyone, while the public hearing's still open and we didn't go to public comment, but public comment would still be open too, but does someone want to make a motion?
Yeah, this is Paul. I make a motion we close the public side of the hearing and vote on the issue of standing.
Okay, so I mean, I need a motion of what we're voting on. And I guess
I'm confused though. Sorry. I got to just stop real quick. If we close the public hearing, we can't. You're shaking your head. Sorry. Go ahead.
Sorry, you're not closing the public hearing. You're going to take the vote on standing, to Attorney Kenny's point. You're going to take the vote on standing because if you do vote that Attorney Ford and his client have standing, the public hearing would remain open and then they would make their arguments on the merit of the appeal. So we have to answer the.
So what was Paul? Sorry, Paul. What's the point of Paul's motion?
So then I make a motion to rule on the issue of standing.
Thank you.
So you're calling for a vote, but you're not calling for. Someone needs to make a motion. I guess I'll make a motion. So I move that the board find the applicant has not met its burden of establishing standing as an aggrieved person under General Law, Chapter 40A, and therefore dismiss the appeal for lack of jurisdiction.
I will second that.
All right. So roll call vote on the motion. Herb Bodenseek.
In favor.
Paul Pinard.
In favor.
Aaron Webb.
I don't know. I mean, I don't know. Again, it's just, can I pass? Can I skip? Can I just
You can pass, you can abstain. You can do either.
I'm abstaining. I'm going to abstain because I don't know. I can't make that decision.
Okay. And Manny Alves?
I'm in favor.
And I am in favor. So 4 yeses, 1 abstention. So the motion passes. Attorney Cogliano, now do we need to close the public hearing or?
Yep, so now you've all voted that there is no standing, and so the appeal is dismissed for lack of jurisdiction, so you can close the public hearing on that matter.
There's 2 matters.
Yeah, both, yes.
Both matters.
So I'll make a motion to close the public hearing on appeal number 2024-039 and appeal number 2024-040 due to the vote of lack of standing on both appeals. Do I have a second?
Second.
All right, roll call vote on closing the hearing. Herb Bodenseek.
In favor.
Paul Pinard.
In favor.
Aaron Webb.
In favor.
Manny Alves.
In favor.
And I am also in favor. So I believe that's complete. Anything else procedurally, Attorney Cogliano, you would like us to do there?
Nope, I think you're all set.
All right. Thank you, Attorney Ford, Attorney Kenny, and Attorney Nickerson.
Thank you, Mr. Chairman and members of the board for your consideration.
Thank you.
Thank you all.
All right. So moving along, we now have appeal number 2025-032 WS Landing at Hyannis LLC has petitioned for a variance pursuant to section 240-65J drive up menu board quantity and area. The applicant seeks to install 2 signs for a drive-through window, including an approximately 35 square foot menu board sign and an approximately 1.25 square foot sign on the menu speaker board. The subject property is located at 790 Ino Road, Hyannis, Mass, as shown on Assessor's Map 311 as parcel 092. It's located in the Highway Business HB and Business B zoning district. This was continued from November 12, 2025. Members assigned myself, Herb Bodenseek, Manny Alves, Larry Hurwitz, and Natalie Pittenger. We did receive a letter from Attorney Cox requesting to withdraw the matter without prejudice. I'll make a motion to withdraw appeal number 2025-032 without prejudice.
Mr. Chair, I think Jeannie Campus is here from Liza Cox's office.
I am. Thanks, Anna. Hi, everyone. My name is Jeannie Campus. I am an attorney at Latanzi, Spalding, and Landreth with Attorney Cox. I'm not here to do much except reiterate our request in our letter yesterday that we move to withdraw the application without prejudice. Thank you.
Thank you. So I made a motion. Do I have a second?
I'll second.
All right, Larry seconds. Roll call vote on withdraw. Herb Bodenseek.
In favor.
Any else?
In favor.
Larry Hurwitz.
In favor.
Natalie Pittenger.
In favor.
And I am also in favor. So the matter is withdrawn without prejudice. Thank you.
Thank you all.
All right, now moving on to new business. Appeal number 2025-035, Ashley Manor LLC has applied for a special permit pursuant to section 240-11C6, condition uses in the RB, RD1, and RF2 districts, bed and breakfast. The applicant seeks to change the use from group home to owner-occupied bed and breakfast. The subject property is located at 3660 Main Street, Barnstable, Mass. As shown in Assessor's Map 317 is parcel 021-001, and it is located in the Residence F2 RF2 zoning district. So sitting on this would be our regular members. Everyone's here. So Herb, Paul, Aaron, Manny, and myself. I'm not sure. I assume, looks like Virginia and Felipe, your application was signed Ashley Manor LLC, so I didn't have a name there. But if you'd like to present your case, if you have anyone else with you, feel free to introduce them.
Actually, Kai Cole is going to be presenting. Yeah.
Yeah.
Oh, sorry, I don't.
Kai Cole.
Okay. Yep. Just introduce yourself.
Hi.
Continue on.
Yes, I'm one of the property owners for Ashley Manor, and we bought the property. It was a group home, but we want to turn it back into a bed and breakfast. It was a bed and breakfast for decades. The house was built in 1720. It's listed as an 11-bedroom building in the assessors, which isn't actually true. It's 5 bedrooms, and then it has the owner's lodge, like owner's room as well. I don't know why it's 11. It says 11 bedrooms, but they said I should mention that, maybe get that fixed. We just want to turn it back into a bed and breakfast. That's pretty much it.
Okay, and you've been to site plan review, it looks like?
No, we don't have to do site plan review. I've spoken with Maggie at the town, because it's been a group home for less than 3 years. So she said we do not have to do that.
Okay.
Mr. Chair, there is a no detriment letter from site plan review in the file.
Okay. All right. Any board members have any questions?
I have a quick question.
Go ahead.
I looked it up on the map today, the address, and it shows it as a bed and breakfast now. Is that incorrect?
It's just because it was a bed and breakfast before, and they never changed it. So the group home was only there for a couple of years, but it's been a bed and breakfast for a long time, so it's still up there.
Okay. And so what year did you say that it was built?
1720, although I think it was like 1699, but 1720 is where the records start.
Okay. And then what's the capacity intended to be, or what's like the room layout?
We wanted to just go back to what it was, which was in the main house, 5 bedrooms, 5 rentable rooms, and then the owners occupying the other space. And then there's also a second building on the property, which is a cottage that was built in 1935. And that was also used as a rentable space. So we just basically want to turn it back into what it was.
Okay. I mean, the bed and breakfast provision says that no more than 3 bedrooms shall be rented to a total of 6 guests at one time. So you would have to follow that.
Right. We want to get a variance on that and turn it back into what it was.
Okay, but that's not what's before us today, or are you asking for relief for that?
No, this is more just a change of use.
Okay. So yeah, go ahead, Paul.
Mr. Chairman, this is Paul. Does the Board of Health have to review this with respect to the requirements for a bed and breakfast versus a group home?
I assume licensing would, but I don't know. Both, I would think.
Right. We're doing the licensing now as well. I think the group home had more stringent requirements than a bed and breakfast because it was a group home for kids from Riverview. So there was a lot of requirements that they had to do to turn it into a group home.
Yeah, no, yes, and I appreciate that honesty. The question I have is, if we approve it as a bed and breakfast, it is still subject to Board of Health requirements.
Yes, inspections and requirements.
Okay.
Have you guys, is that public water service there, or is that a well?
Public.
It's not public water. It's on, it has towns, it has sewer. It's not connected to the town.
Sorry, so it's a septic system, but is it public water or is it well, town water?
Town water.
Yeah, it's town water. Town water.
So did you get a determination of the impact of the water supply?
Yeah, actually, I mean, we actually can even have more rooms, frankly, from what we have researched. And actually, that's the whole point also about the 11-bedroom thing. I'm not really sure why it says it's 11 bedrooms, but that was part of the study that they did about what the capacity was, and it can hold a lot more.
Okay.
Or it can handle a lot more.
The septic system can. The septic system can handle more. And you're on town water.
Yeah.
There's no well. There's no well.
And we're on town water.
Okay.
No well.
Okay. I'm just looking at the, what we have to, the conditions we have to make sure are within within the guidelines.
Right.
And then there's no plan for cooking facilities in these rooms.
No. Mm-mm. There's only the kitchen in the owner's quarters.
Okay. And then on the site plan you provided, where exactly is all of the proposed parking, or how many cars are you proposing to be able to accommodate?
The parking, when I talked to the city and we looked everything over, there's more than adequate parking. And that's what they saw in their site plan as well. But we have, parking is already existing. Like I said, it was run as a bed and breakfast for so long, it's pretty, it has like a circle, so you can go up the driveway and you can go around, but then there's like 4 spaces off to one side, and then there's another 3 spaces, and then there's another like 4 spaces. There's plenty of parking.
Okay.
So how many parking spaces? We need to know a number.
So I guess technically, 4 plus 3, so 7, and then I think another 4 car. I think it's like 11. It could fit 11 cars.
Okay, because the site plan does not reference a certain number of parking spaces. It just says that it highlights a gravel parking area.
Yeah.
But again,
the town had it when I talked to Maggie. She's the one who said we didn't need to do a site plan review or anything like that, and she was like, "There's plenty of parking," so that was clear. I'm not sure if they have a different plan in the town to show the parking, but she could see it.
Okay, I mean, we're looking at what you submitted, and then item 7 requires that no parking shall be located in any required building, yard, setback, and parking areas shall be screened from adjoining residential properties by a fence or dense plantings not less than 5 feet in height. So I can't see on that plan if that exists or not. It further says
you can't see it from
permitted in front of the house, not within the required building front yard setback. So the plan from
there's like hedges in the front.
Not reference that, does not have those lines on it for us right now.
Yeah, sorry, I didn't know we needed to have those.
Are there other board members with questions or thoughts here?
Well, I have a question, a general question. Maybe this is for the board. So if you look at the history of this, as recent as 1999, there was a modification to a special permit. The then existing special permit allowed the use as a B&B. I guess I'm wondering, we continue, a couple of questions. Are we continuing that thread of amending the existing special permit back to allow for, because that's not how it was advertised, right? This is just.
I don't see that as the ask here. The ask here is asking us to approve this based on 24011C as a conditional use under, our
right. No, I get that, and that's how it was advertised. But then there will be a follow-on variance request to allow for more than 3 bedrooms. I guess I'm just wondering if it wouldn't be more efficient to sort of handle this at once. Anyway, I hear
that would be great.
That would be
no, I don't mean now, because it hasn't been advertised as a request for a variance.
Mm-hmm.
But it would just, given the history, I mean, I don't know if the board's willing to proceed just as it was advertised, I'm fine. We can do this under 24011C. Although I don't know that we can meet the requirement that there be no more than 3 bedrooms.
I also don't. I think we need an updated site plan that shows the parking based on the requirements as well.
Yeah, that's why it may make sense to sort of put a package together and perhaps have one request before the board, as opposed to doing this piecemeal. Because I don't see how we do this under 24011C6.
Yeah,
that's more of a comment than a question. Sorry.
Yeah. I mean, Ms. Cole, what's your thought on that? So I don't know if Anna sent you the staff report, but there's 7 or 8 items that are required for us to approve what you've requested, and then we would also be conditioning this that you couldn't have more than the 3 bedrooms.
Well, what we were told was that what we were told is that it because it became a group home, it basically we can't transfer that it was a bed and breakfast into a new owner being a bed and breakfast, that we had to start from scratch. So that's what we are doing. We do want it to be what it used to be able to rent out the 5 bedrooms plus 1, carriage house or cottage. But we thought we had to just go through these steps in order to, because it's brand new. Like, basically what we were told is it doesn't matter that it used to be a bed and breakfast for 3 decades, 4 decades. It doesn't matter that we have to start over. So that's what we're doing.
Yeah, I mean, that's what's before us. That's what you put before us is, this could be any old big house on 6A that's coming before us to convert to a B&B. So, but we're just concerned that there's more, we're only going to get you a little ways here if we push this forward, and we might be missing a few pieces of it. So it may make sense for us to continue this to a future meeting. You sort of regroup and put the whole package together of how many bedrooms, what you want it to look like. I'm not an attorney or giving you any advice, but there may be an opportunity with that cottage to create an ADU with that or something. You'd want to talk to an attorney about, how you could make that fit. But it sounds like that might make the most sense here. But it's up to you. If you want us to try to move this forward, I know that I don't feel comfortable with number 7 with the current site plan you've submitted. I'd ask you to go back to Downcape and have them draw your parking and put your setbacks on there, give us a number of parking spaces, and just make sure it complies with that bylaw.
Well, I am wondering, just 1 second, because I am also wondering because, when I was speaking with the town, that it seemed like they had the drawings and they saw the parking, which is why, one of the reasons why they said it was okay for us to we didn't have to do a site plan review or anything like that. So that's why I'm wondering, and she did send me those documents, but I'm wondering if it shows the parking on those old documents, you know, for the people who maybe made it into a group home or something like that. I'm sure that's not, you know, that would be pretty easy for us to do. I mean, the parking is there. It's not like it's not there and we have to create it. So it's been there forever. I mean, so what you're saying is basically this step is not useful for us. We should just go and kind of do the variance at the same time, trying to get the rooms back the way that it was. Instead of doing the 3 bedroom change of use, postponing it to the next session and trying to get the maximum that we want back to what it used to be.
I think,
is that what you're saying?
If I'm wrong, I think that's what makes the most sense to, like, here's what you guys are trying to do, the full project, and we can approve it and condition it based on, you know, the full package. I wouldn't withdraw this because you're already in. We might as well continue it, but you'd have to work with Anna. You may have to send out a separate notice for if you're looking for a variance. That may be a separate number, but we would hear them concurrently.
Right. We kind of thought that was what was going to happen anyway. So, I mean, I feel like, so what is the negative of us doing this right now? What is the negative of us getting this approved? Is there a negative?
I mean, we're going to condition it, so you're going to have to come back and modify this as well as the variance, I guess. And then also, I mean, I'm only one voting board member, but I don't think we can satisfy number 7, is my opinion, without a site plan to be able to reference that has the parking and the setbacks and the buffers. That's just, you know, our power is limited here by what is written in our bylaws. So we have to check these boxes. Gotcha. That's why I was asking the questions about the well and things like that. Those are all items in here that need to be checked. So I would suggest when you come back, just make sure all 8 of those things have been answered, and you can walk us through each one. And then you'll be asking for a modification or a variance for number 2, the 3 bedrooms.
Okay.
And again, we'll want you to sort of justify that of how, you know, why, and, you know, tell us about the history and things of that nature.
Okay. That makes sense.
Go ahead, Aaron.
Just looking at the you know, zoning rules for the town. I mean, if 3 bedrooms is going to be tough. If this is would it fall under the classification of an inn?
No.
More so than a bed and breakfast?
I don't know. I don't know where inns, what districts inns are allowed in, or hotels.
It seems like to me, with the amount of bedroom counts, it's not. Anyway, just a thought. I would look into the inn convention personally, but you know, again, it's larger than a bed and breakfast at this point with the amount of bedrooms. So I don't quite understand how that. You know, that's just 2 cents.
Yeah. And the only thing I would add is, I don't want to give you legal advice, but the way this has been done in the past is by modifying existing approvals. You may want to talk to a lawyer if that's not to see if that's not an easier path, because there's a special permit that allowed the use here that you're asking for. It was changed to a group room, to a group home. The question is, is it going back one step easier than going through again, you may want to get advice on that. But we can proceed the way you framed it, or maybe take a path of least resistance. I don't know.
Yeah, it's going to be a repeat of 1998 62B and 61B. Basically, they're just going to do that all over again.
Yep, we're going back.
So
So can I make a motion to continue at this point?
Yep.
Is that agreeable, Kai and applicants?
Yeah. I mean, I mean, if that's what we have to do, then that's what we will do.
Okay, so I make a motion to continue.
Do you have a date? Hold on, we need a date.
Sorry? Oh.
Date.
How much time do you think you'll need? A month? 6 weeks?
No, less than that. I mean, we have all the information.
Our next meeting isn't until January 14th, so it's going to be a month.
Okay.
Yeah. Oh, well, then it's a month.
Good point. And 14th is busy though, Anna, correct?
There is the comprehensive permit and 2 other items on there, so it's up to the board.
Comprehensive permit is the 40B in Centerville.
Yep.
This is Paul. I second Aaron's motion.
That's gonna be a marathon though, that 14th. I mean, so.
Yeah.
2 other applications are variances also.
So do we want to put it to
Ours will be very quick, very quick.
I get it, Kai, but it's going to be, you know, again, I hear you, but the 14th is going to be a marathon without yours involved already. So anyway.
The hard part about this is that we bought this place in May and we've been trying to do the right thing the whole time. And, you know, we want it to be able to be operable by the summer. And it's just like, everything seems to be not going our way. So it's been a struggle.
Well, this is Paul. Put it on the agenda.
That we can get it approved so that we can, you know, be ready to market and open for business in the summer.
Okay,
we get all that. That's you know, no, we understand your issue, but again, so I say it's got to go to the second meeting in January. Personally, my opinion, but.
I think you put it on the agenda for the earliest one. If it doesn't, then we continue it to the next one. I mean, let's.
But Paul, what do you mean if it doesn't? What does that mean? If it's 10 o'clock at night, we just kick it off?
Well, what have we done before, Jake?
We've not voted on things and upset applicants.
Right.
Sat there for 3 hours.
Well, okay. So ask the applicants. There's a chance that we may go so late you can't be heard on the 14th, but it's worth a try because it doesn't cost anything except your time. Do you want to go forward with that, or do you want to postpone it further?
We would love to go forward with the 14th.
Okay, there's their answer. Let's put it on there.
And so just to warn you, as Paul said, like last time we were working with that applicant on that one, we did go until I think 10:30 at night, maybe even 11, and we did just sort of call it. So it may be a situation like that where you sat there for a few hours and we just, unfortunately, our bandwidth sort of burns up to tackle things. So sometimes we have to
That's okay. This stuff is interesting. The other stuff is really interesting.
Well, one other thing to note, actually.
Make us wait till midnight for your hearing.
We're here twice a month. You can come back and hang out anytime.
My motion here.
Hey,
I make a motion to continue.
We're always looking for members. If you're a town resident,
Sorry, one thing, Ms. Cole, the January 14th meeting is in person.
Yes.
I know you're
no problem.
Out of state. Okay. Just wanted to let you know.
No worries. Yeah.
I think Attorney Nickerson wishes to be heard.
Oh, go ahead, Attorney Nickerson.
Thank you, Mr. Allison, Mr. Dewey. I just thought perhaps the applicant should be advised as to when an application for any additional zoning relief would have to be received in order for that to be placed on that same meeting date, should they decide to seek a different modification of special permit or any additional relief that might be granted. Just might.
Yes, thank you. Anna, do you know what the deadline would be for? It'll be pretty soon.
Well, the deadline to get on the 14th is the 23rd of December, but we have vacations coming up, so Jenna and I were talking about the 22nd being the deadline.
Okay, and a butters knows we can get out if they need to renotice in that time?
Yep.
Okay.
And that's basically that we have to have everything submitted by the 22nd that you need, all 8 items on that list.
We have to send it to the newspaper on the 22nd, so we need to get the information before that.
Okay, no worries. We'll get that for you.
All right, so Aaron's made a motion to continue to January 14th, 2026, and Paul has seconded. Roll call vote on the continuance. Herb Bodenseek?
In favor.
Paul Pinard?
In favor.
Aaron Webb?
Sorry, I'm in favor.
Kenny Alves?
In favor.
And I am also in favor. So you guys are continued. Feel free to work with Anna and Jenna with any help or follow up with some of the comments we made.
We will. Thank you.
We'll see you at Town Hall then.
All righty. Thank you.
Last item for tonight, appeal number 2025-036. William and Susan Sullivan have applied for a modification of special permit number 2006-076 pursuant to section 240-91H, developed lot protection, demolition / rebuilding on a non-conforming lot. The applicants are seeking modifications to approve the conversion of the existing barn into a garage with finished office, remove the existing deck, and construct a 395 square foot swim spa and a 23 by 27 foot patio, and revise and update lot area, lot coverage, setbacks, floor areas, and floor area ratios per engineer's plan. The subject property is located at 990 Main Street, Katuitt, Mass, as shown on Assessor's Map 034 as parcel 034. It is located in the Residence FRF zoning district. So again, all our regular members are here.
Mr. Chairman, real quick, I'm sorry to interrupt. I need to jump off here. I have something I have to attend to. So is that okay if somebody takes my spot?
No problem.
Wait. Mr. Chairman, I've recused myself from this particular matter.
Okay. We have enough members here tonight that both of you, we can move on without both of you. So that's totally acceptable.
Thank you so much. I appreciate it.
All right.
Thank you, Mr. Chairman.
5 members would be Herb Bodenseek, and Manny, Larry, and Natalie would be 5. Yeah, and myself. Is everyone good to sit on this?
Sure.
Okay. All right. Attorney Nickerson, Attorney Kenny, over to you.
Thank you, Mr. Chairman, members of the Zoning Board of Appeals. For the record, my name is Patrick Nickerson, attorney at the law office of John W. Kenny, who's with me here tonight. Also with me is Bill Sullivan, the applicant, and John O'Day, who is here available to answer questions. He may also be involved in an in-person hearing still with the Shellfish Commission or the Shellfish people. I'm not quite sure what that is yet, but he'll jump in for questions if he's able. Mr. Chairman, we're seeking modification of special permit this evening to approve some work that's been done and for permission to construct a pool to the rear of the property. The address is 990 Main Street, Katuitt. If anyone tried to drive by the property and couldn't quite figure out where it was, I won't blame you. There's a long shared driveway which provides access from Main Street. The building itself is located directly behind the Mariners Lodge building, or the Masonic building. It's access to Main Streets on a private way, which is also shared by 992 Main Street and 994 Main Street. A third abutting property, 980 Main Street, has access off a private driveway, which is located on the subject property. We did submit a project narrative and a zoning memorandum to you to help you consider some of the issues. Essentially, in a nutshell, the lot was created in 1947, which predates dimensional requirements in the town of Barnstable. The subsequent zoning amendments in 1956 and 1969 rendered both the property and the structures thereon non-conforming. In 2006, this board issued a special permit allowing the complete demolition and rebuilding of the single-family dwelling on the property. 2 conditions were in the decision. One was sort of a standard condition that the proposed construction is considered to be full build-out of the site, and a more specific condition required that the barn not be turned into, quote, habitable space. In 2008, the applicant did apply for and receive building permits to renovate the barn and improve it. Those building permits were issued, which essentially resulted in 300 square feet of finished space, which is used as an office. It's important to note that it's certainly not a dwelling. There's no bedroom. There are no kitchen facilities whatsoever. And in hindsight, the applicant should have returned to the Zoning Board of Appeals in 2008 prior to completing that work. but it is not a dwelling, has no bedrooms, and does not result in an intensification of use. The applicant is also seeking to remove a rear deck on the main house and construct a pool patio. This will increase the lot coverage within the amounts required under 240-91H and update certain technical data as further set forth in the project narrative. With that, I'd be happy to share my screen and take you through the site plan as well as any pictures of the office space, as well as address any questions you may have. So Sarah, could I have permission to share my screen?
You're all set, go ahead.
Okay, thank you. So here's the site plan that's been prepared by John O'Day. It shows a portion of the private way I was discussing.
I'm not seeing it.
Can't see it yet.
Oh, I'm sorry.
I don't see it.
I got to press the blue button. How about now?
Yep.
Okay, thank you. So the site plan here has been prepared by John O'Day. The 18-foot private way I referenced is here to the left of the property. This provides access to two other properties. This lot here is owned by the Masonic folks, by Mariners Lodge. That's the building directly in front of the garage and dwelling. This shows a combination of existing and proposed conditions. So we have the existing garage here, which is not proposed to be changed. I'm seeking simply permission to approve the work that's already been done. To the rear of the house is where the pool will be located with the patio. Neither of them would be present from public way. Importantly, also, both direct abutters have indicated their consent to the project and issued letters of support, which are in your building file. The updated technical data is located here, related to setbacks, lot coverages, gross floor area, etc. If I could take you through the exhibits provided in the project narrative, this is the original decision, which is in your packet. Here are some of the building permits I referenced in 2007. The permit allowed for new foundation under existing shed to create boat storage, deck above extension of foundation 22 by 20. Building permit was issued. Another permit here. Another permit here. This called for re-roof, re-siding, replacement windows of the shed. This permit was from 2007. Another permit here from 2008 called to add insulation and heat to existing workshop, 300 square feet. Permit was issued, inspections were done regarding the frame, insulation, final building. Plans were provided to complete the work here, showing I'll rotate my screen now if that's okay, showing the existing shed, the proposed basement boat storage plan. This area is not included in gross floor area under the ordinance. And showing essentially the scope of work. There was sort of a dig out of the grade and a unfinished garage space not included in gross floor area was constructed underneath. Both storage space is shown here. The existing storage shed is shown here with the roof deck on top of the new foundation. Additional plans here. I'll rotate my screen again. We have some pictures of the inside of the upper portion of the garage. You can zoom in here. This is Bill's son, seated at the table with the monitor and computer. This gentleman here is opening the pull-down door, demonstrating that there is some access to this very narrow loft area. We don't believe this is considered habitable given its relatively low ceiling height you can't stand up there directly. There is a half bathroom in the finished space. A picture of that is shown here. Picture of where Bill's son was sitting is here at the office. There's a couch here by the window. There's an egress door. The main dwelling is here where my mouse is. And then finally, we provided for your records a foundation plan, which showed the measurement of the foundation of the main dwelling being 9.5 feet from the side yard setback and 7.9 feet from the side yard setback. This was prepared by Baxter and I Engineering, was located in the building permit file. John O'Day's calculations were somewhat different, but we wanted to present you with the foundation plan showing those measurements for your purposes. I can also show you the exhibits from our zoning memorandum. I've summarized this briefly, but here is another look at the property. Here it is, 990 Main Street. Here's the private drive I referenced, which provides access to the subject property, 992 Main Street, 994 Main Street. The other abutting property at 980 Main Street is accessed by way of a private driveway here. The pool would not be visible at all from any public way, and both abutting neighbors have indicated their support. We also provided for you a copy of the original plan proving the lot predates any zoning requirements. This was recorded in 1947. And then a GIS map from 1951-52 showing both the barn and the original dwelling since demolished and rebuilt, proving that they both predate the 1956 requirements of the zoning ordinance. So I'll stop sharing my screen now and turn it back to the board, ask if there are any questions that I may address. And if I can't answer them, I'll ask either Bill or John O'Day to help me out. Thank you.
Thank you, Attorney Nickerson. I mean, I guess my only question is, why can't this go under H1? What exactly is triggering that you need the special permit?
So it was required because the side yard setbacks were less than 15 feet required in the RF in 2006.
Okay.
Despite really having no frontage of the main house anyway, I mean, it really fronts on the back of the Masonic lot. The side yard setbacks are what required the special permit.
Okay. Any board members have questions for the applicant? Manny, go ahead.
Was that me? Sorry.
Yeah, go ahead.
Okay. So I saw something in your memo, Attorney Nickerson, saying that the Sullivans acquired title in 2020. That's not correct. They were the parties who got the special permit in 2006 as well. Is that right?
Yeah.
Yes. Yeah. In 2004, that is the exhibit.
That was just the typo. That's okay. The reason I ask is the section under which you're seeking relief, 249-191H, has a requirement that the lot coverage not exceed 20%.
That's correct.
And I didn't see that anywhere in your materials. What will the lot coverage be if the proposal, as you presented it, is approved?
It would be 19.9.
It's in the staff report, Manny.
Right below the toilet. Okay, that's
yes.
right.
And the floor area ratio is 29.5, where 30 is allowed.
Okay.
Yes.
All right. I got it. That was. Oh, the other thing is, there are two abutters you said that approved this.
Yes.
That 980. The ones on those at 994, 980. 992 is the third. Did you hear from them at all?
I didn't. This is Bill Sullivan. I did not reach out to them. It's an elderly couple who I easily can.
Okay.
They're super nice people. I didn't want to torture them, but that's it. It's not hard for me to reach out.
You're not required to. I was just curious because they're also right there.
Yeah, one of them's had some health issues this past year, and so honestly, I just didn't want to bother them.
Thank you.
Natalie, I think you had something maybe?
Yeah, well, I don't know. I guess one of the things that bothered me was the, on page 3, I guess, is exhibit number 2, when they specifically said the barn should not be habitable. And yet they went ahead and made the barn habitable. Supposedly.
Well, I mean, I'll pass that back to you, Attorney Nickerson, the definition of habitable, but go ahead.
It could be open to interpretation what habitable means. Does that mean it's not to be a dwelling, or does that mean it's not capable for any human occupancy as defined in the ordinance as it is today? Certainly with the benefit of hindsight and with the opinion of counsel, the advice would have been to, of course, return to the Zoning Board of Appeals, knowing how gross floor area is defined under the ordinance. For a layperson, that may not have been understood. And the work was done pursuant to 3 different building permits that were lawfully issued. So certainly with the benefit of hindsight, would have advised Bill to come to the Zoning Board of Appeals first, seeking a modification of that condition. But that did not happen. And that is one of the reasons why we're here today, asking for your permission to approve the build out of the garage. So with the understanding that, I'm sorry.
Yeah, no, I was going to say, so you would be asking us to approve the building or the adjustments or the construction that was done to the barn over the years.
Yes, I believe your approval is required based upon how gross floor area is defined under the ordinance. I would interpret the prohibition that the barn not be converted into a habitable space as being not to create any gross floor area within the barn. I'm presuming, I have not watched the tape back from 2006, but I'm presuming that the barn was found to be not included as gross floor area and not habitable, despite being an enclosed structure. Because what's interesting is that an enclosed porch under gross floor area is included within gross floor area. So
this is Bill Sullivan. I mean, for what it's just add a little color. You know, I was told that it certainly, you know, you can't, it can't be used as a bedroom, but it could be used. It was always intended to be space where I could work, and that's what I've done. I've worked there for years, you know, when I'm up there. And so it was never indicated to me, you know, ever that this, there was like, it was never discussed with me by the builder, by the way, who handled all this for me. It was Jimmy Crocker. That like, it was always, you know, like we could use it as office, but you could never use it like as a living space or bedroom. So this was all kind of a surprise to me, a recent surprise, because I know we got the permits to do the work.
Yeah, the other thing was to one of the exhibits, I guess, had a different name on the site plan. Was there something special going on there?
If you're referring to the exhibit from Matt Eddy, that was provided only to show how the setbacks were measured from the foundation upon the construction of the new dwelling. John O'Day's numbers are slightly different. He finds that the northerly side setback is 9.8 and that the southerly is 7.5. We're asking the board to find and determine the setbacks are 9.8 and 7.5. We thought, and since we're modifying condition 2 and 7, we could also modify the technical data to the extent there are minor conflicts between what John O'Day found and what Matt Eddy found back in 2000. 6 or so.
Okay.
So, Attorney Nickerson, the loft above is not being calculated in the floor area ratio.
That is our position. It's not included because there's no standing room height in that portion.
But it is conditioned space.
Correct.
Okay. I mean, I think we're walking a fine line there, but
yeah.
I don't know what other board members think about that. I mean, I think that needs to be an attic or unhabitable space. I mean, I guess you can say it's low, but that's I mean, it's got a finished floor, I assume it looks like from the photos. Correct? Or it's unfinished?
Bill, is there a finished floor up there?
I think it's plywood up there. I mean, I don't even know if there's anything up there. The truth is, I have no problem dismantling the law. I mean, it's just not used. So if anything is up there, it's probably some boxes related to my businesses. So, I can't go up there. You can't even stand up.
Mr. Chairman, it's not unusual to have space like that not included in gross floor area. I'm thinking like attic space with this, you'd know better than I, but a knee wall, and I forget how high the knee wall has to be, but space behind a knee wall is not included in gross floor area because it's not occupiable. And that's what this is akin to.
But that's unconditioned space. Your thermal layer is right there at your knee wall.
You can have conditioned space, behind the knee wall. Like, let's say you've got a finished garage and you want to make a room up there, and you put, I don't even know what a knee wall is, but you put walls in, and the space behind it can still be conditioned.
Okay. So, I mean, I mean, even if we did add that area, we'd be pretty close still. Would we still be underneath if it was that, or that would push it over the 30? I can't tell how many square feet that is up there, but.
That I don't know. I don't know how big that area is. It's not very big.
Because we're at 29.5. I mean, we've got to be, it might even have been fine. I don't know how many square feet it is, but.
I don't even know.
Would a condition of removing the staircase so it's not accessible satisfy the board?
I mean, again, it's just the things we're seeing all over the place. It could very easily be, there can be 4 mattresses up there and it's a bunk room with a ladder that goes up the front. That's all I'm saying. I've seen plenty of them. But I mean, I don't want to tear this apart if other board members are comfortable with it. I just was pointing out that we're right on the edge here and we're sort of defining that space. Are there any other board members have questions or concerns before we open public comment? All right. Seeing none, we did receive the 2 letters, one from Susan and Charles Nardone in support there at 994 Main Street, and one from Bill and Kathy Lapointe at 980 Main Street. Get to it. Again, in support. Is there anyone here that wants to speak to this? No. All right. Seeing none, I'll make a motion to close public comment.
I'll second.
All right. Roll call vote on closing public comment. Herb Bodenseek.
In favor.
Larry Hurwitz.
In favor.
Annie Alves.
In favor.
Natalie Pittenger.
In favor.
And I'm in favor as well. So the public hearing is still open. If there's any more questions for, go ahead.
So this is framed as a request to modify the 06 special permit. But I looked at the staff report and maybe I missed it. There was no reference or no finding there going to that point. Attorney Nickerson, do you read it that way as well? I was just curious. Because this just seems to be approving what you're proposing. It doesn't seem to be retroactively addressing the 06 special permit.
It was applied for as a modification of the special permit. The board does have the authority to modify special permits.
Understood.
And the relevant section really is upon which the initial special permit was granted. There's no standalone provision in the ordinance that would direct the board upon which findings must be made before modifying a special permit. It's just the general powers of the board, that there's an application that's specifically exempted for in the form of a special permit, and that it may be granted without substantial derogation of the public good or the neighborhood affected.
Understood.
Given the letters of support in the file, given that the improvements to the pool and patio won't be visible from any public way, you could grant the relief with respect to the pool in furtherance of those sections of the ordinance. Also, there are no proposed changes to the barn or garage. It's been there since 2008. There are no bedrooms. It's not intensification of use. You could approve that request as well. And then finally, just regarding the technical components, you could find and modify those figures to the extent there's a discrepancy between John O'Day's plan and Matt Eddy's plan. The only physical changes to the site that are actually being proposed are to the rear deck of the main dwelling and the pool to the rear dwelling. There are no actual proposed changes to any setbacks of the principal dwelling or of the barn. So you could make those findings and amendments there too under the general powers set forth in the ordinance.
So is the pool encroaching, or the pool, you're not asking for relief for the pool?
We are not. We consulted with Brian Florence on this. The pool does not need to adhere to the setbacks of the principal dwelling.
Okay.
This would be done as of right, but for condition 7 of the original special permit, prohibiting further build out without your approval.
So I guess back to Manny's point, why are we not just, I mean, I see the request was to modify, but why are we not just making a motion to modify the 20, whatever it was?
Yeah.
Yeah, 2006-076.
Aren't we modifying it after the fact? It was already modified, the property.
I mean,
no, the two provisions of that special permit that we need to modify. One is to, obviously, we're approving this by nullifying the one that said that it was then a full build out. And then the second is the no habitable space, which is your point, Natalie. Anyway, I take your point. I think the board has the authority by approving this special permit. In essence, we are. Maybe that's the way you're viewing it. We're modifying the prior one, but if there's no specific reference to the 2006 special permit in these findings. Anyway.
Manny, there is a reference in the conditions that it's a modification of the 2006 special permit. The first condition.
Okay.
I like that we just modify the existing permit rather than creating a new one. But
right, exactly, because there's no other requests being made.
No.
Do you agree, Attorney Nickerson? If we just took out those two provisions from the 2006, you could just, everybody goes along merrily.
Well, I would agree that the proposed special permit findings as set forth in the staff report per se are not needed, but there is certain information that's helpful regarding lot coverage, which is increasing. Same with gross floor area, which was not explicitly defined in the original decision. So I guess we would we would ask the board to make a finding to modify the special permit to allow the additional build out of the pool and patio to the rear of the principal dwelling pursuant to condition 7. Also to approve the additional build out of the garage with finished office pursuant to condition 2, and update the certain technical data detailed in the project narrative, which we submitted with our application for special permit. And then if needed, I could consult with Anna and provide whatever assistance is needed regarding the proposed decision, written decision. There are 8 technical data points we're asking to be updated regarding the decision. But
those data points aren't falling within, you're saying they're not falling within the existing special permit then? They're exceeding it?
Well, as a result of the increase in lot coverage, as well as the differing data found between Matt Eddy and John O'Day.
But you don't need relief for that. The building commissioner has concurred. So I don't think we need to get into that if it's not necessary. But Manny, what's your thoughts?
Yeah, that's when I first read it. That was my original thought. It's because I appreciate the interest in having those data points there, but you don't need relief for them. You're staying within the limits. We could proceed the way it's been advertised as a modification, and just add an extra finding that even if it's not explicitly there, that by approving this special permit, we are anything inconsistent in the 2006 special permit is hereby superseded or something. Something to that effect. It's just, to your point, Jake, I didn't know that we needed a new special permit here.
Yeah.
Pat, did the gross floor area calculation change?
The gross floor area ratio wasn't determined in the initial decision.
Yeah. So that was some of our concern, is basically the full build out, and that's a condition that's often in your decisions, even though you meet the zoning, you're below the zoning allowance. You oftentimes put in there that it's considered to be full build out, and there's be no further build out without permission of the board. So I tried to argue before to take that condition out.
It is, by the way, a condition to this special permit.
Yeah.
So how would we like to proceed, board members? The public hearing's still open, so we need to close the public hearing to move to findings, but do you have are you ready to make findings, Manny? I'm putting it on you.
Me and my big mouth. I think if that's okay with the applicant, because I think it accomplishes both. If we just add one that just says, because I think putting it as a condition, and thanks for pointing that out, Anna, I missed it, is not really, I guess I would say, affirmatively amending or modifying the prior special permit, but we could say that. We could just say, we make the findings if the board so votes, and then just say that we're amending the 2006 special permit with the issuance of this special, because this will be a new special permit. Right?
Yeah.
So,
I mean, if we're granting the special permit, that it's in the staff report, but what was noticed was a modification.
Yeah. And I guess we're modifying we're beating this to death. We're modifying the 2006 special permit by issuing this 2025-036 special permit.
Yeah, I mean, we're kind of nullifying it, right? This supersedes it now?
Yeah.
So I'll make a motion to close the public hearing. No more testimony can be taken. I need a second.
I'll second.
Roll call vote. Herb Bodenseek.
In favor.
Larry Hurwitz.
In favor.
Any else?
In favor.
Natalie Pittenger.
In favor.
And I'm also in favor. So the public hearing's closed. Does someone want to make findings or deliberations on the matter?
I'll make findings if there are no more discussion.
All right.
Okay, so this is on the application of William and Susan Sullivan for a modification of special permit number 2006-076 pursuant to section 240-91H, develop lot protection, demolition, rebuilding on a non-conforming lot. The applicants are seeking modifications to approve the conversion of the existing barn into a garage with a finished office, remove the existing deck and construct a 395 square foot swim spa and a 23 foot by 27 feet patio, and revise and update the lot area, lot coverage, setbacks, floor areas, and floor area ratios per the engineer's plan. As I guess my findings would be that the application falls within a category specifically accepted in the ordinance for the grant of a special permit, in that section 240-91H allows for what's being proposed here. Site plan review is not required for single family residential dwellings. And I find that after an evaluation of all the evidence presented, the proposal fulfills the spirit and intent of the zoning ordinance and would not represent a substantial detriment to the public good or the neighborhood affected. I specifically note the approvals or non-disapprovals of the abutting neighbors, and the fact that the proposed work, one, is done in terms of adding an office to the garage, and that the spa pool and work to the back towards the water would not be visible from any neighbor's perspective, and would certainly improve or represent an improvement on the property. So this would not represent a substantial detriment to the public good or the neighborhood affected. Section 240-91H requires the board to find that the proposed demolition and rebuilding, as in this case, where it cannot be done as of right, the board may allow the demolition and rebuilding by special permit, provided that the board finds, and I so find, that the proposed yard setbacks must be equal to or greater than the yard setbacks of the existing building. The setbacks for both dwellings are not changing. And the proposed setbacks for the swim spa area are 6.7 feet and 9.4 feet. The proposed lot coverage cannot exceed 20%, or the existing lot coverage, whichever is greater, and the proposed lot coverage in this case will be 19.9%, less than the maximum permitted. The floor area ratio cannot exceed 30% of the existing floor area ratio, and the proposed gross floor area is 29.5%. The board must also make a finding regarding building height. It cannot exceed 30 feet to the highest plate and contain no more than 2.5 stories. The proposed height of the dwelling is 23.5 feet and will not change. Boards also asked to find that the proposed new dwelling, and I guess I've made this finding already, would not be substantially more detrimental to the neighborhood than the existing dwelling. Lastly, the proposed side yard setbacks of the single family dwelling are 9.8 feet on the northern boundary and 7.5 on the southern boundary. Those are my findings.
All right, do I have a second?
Second.
All right, roll call vote on Manny's findings. Herb Bodenseek.
In favor.
Larry Hurwitz.
In favor.
Any else?
In favor.
Natalie Pittenger.
In favor.
And I am also in favor. Many conditions.
Yeah, they're numbered 1 through 6 in the staff report dated November 18th, 2025. I know that there's one in there that Attorney Kenny is not partial to, this constituting a full build out. But are you okay with these, Attorney Nickerson, Attorney Kenny?
Yes, I am. Bill, you're okay with the conditions 1 through 6?
Yes.
Okay. Thank you. I'm okay with them too.
Okay, so the conditions, and as I said, numbered 1 through 6 in the staff report dated November 18th to 2025.
All right, and I need a second on the conditions for 2025-036.
I'll second.
All right, roll call vote. Herb Bodenseek.
In favor.
Larry Hurwitz.
In favor.
Annie Alves.
In favor.
Natalie Pittenger.
In favor.
And I am also in favor. And then we need to make a vote to pass the item as discussed and as presented as findings presented. Need a second?
Second.
Roll call vote on approval. Let's see. Herb Bodenseek.
In favor.
Larry Hurwitz.
In favor.
Andy Alves.
In favor.
Natalie Pittenger.
In favor.
And I'm also in favor. Attorney Kenny, Attorney Nickerson, you guys are all set. Thank you very much.
Thank you all very much. I don't know if you can hear it, but outside our office is 2 massive excavators tearing up Route 28. It's been humming all night. I hope it wasn't coming through the mics.
No, didn't hear it.
From my house.
Good night, all. Thank you.
Thank you. Have a good night.
Thank you all very much.
Great job, Attorney Nickerson. Yes.
All right, correspondence, Cape Cod Commission member workshop 11/20/25 at 1 p.m. We had the Cape Cod Commission meeting 11/20/25 at 3 p.m. The technical bulletins hearing 12/4/25 3 p.m. virtual. The Witchmere Beach Club hotel redevelopment 12/16/25 5 p.m. at the Harvard Community Center. Cape Cod Commission meeting Thursday, December 4th, 2025 online. Pound Pond mitigation hearing Thursday, December 18th, 2025 hybrid. The Barnstable LCP hearing is Thursday, December 18th, 2025 hybrid meeting. Executive committee meeting agenda on Thursday, December 4th, 2025. And that is all. Anything that we didn't anticipate? That is our last meeting for the year. We'll see everyone in January for our comprehensive permit.
Merry New Year.
So January 14th, January 28th, and February 11th. I'll make a motion to adjourn. I need a second.
Second.
Roll call vote on adjournment. Herb Bodenseek.
In favor.
Larry Hurwitz.
In favor.
Annie Alves.
In favor.
Natalie Pittenger.
In favor.
Deborah Dworkis. She's here. Yeah, still here. Oh, you're muted. And I'm in favor.
In favor.
Happy New Year.
Thank you, Deborah. Happy New Year, everyone. Sarah, we're all set.